Good morning. I'm Gary DeWaal, and this is Bridging the Week for January 11th to 15th, and today is January 19th, 2016. Last week, a non-U.S. broker was sanctioned by the Commodity Futures Trading Commission for purportedly dealing with two institutional U.S. customers without being registered as a Futures Commission merchant or exempted. In the U.S., a broker-dealer was sanctioned for alleged breakdowns in its compliance with Securities and Exchange Commission rules regarding short sales. Also, industry organizations tried to help the court in a CFTC enforcement action by pointing out that the CFTC is trying to use an incorrect standard to prove a charge of attempted manipulation. Regulators still have not gotten really revving in 2016, but we have a few important articles to cover, so let's get started. Equity Capital International Ltd, a UK-based broker, agreed to settle charges with the Commodity Futures Trading Commission that it solicited and accepted orders and funds from two U.S. persons without being registered with the CFTC as a Futures Commission merchant or exempt from registration from June 2010 to October 2013. According to the CFTC, Equity facilitated the trading of two U.S.-based affiliates of institutional global proprietary trading organizations that were automated algorithmic traders. After processing an application for exemption from FCM registration with the Financial Services Authority during 2011 and 2012 to ultimately be passed on to the CFTC, Equity learned in September 2013 that it was handling the two U.S.-based customers and self-reported itself to the Financial Conduct Authority, the successor to the FSA, and the CFTC. The broker ceased handling the customer's business the following month. Equity agreed to pay a fine of $140,000 US to resolve the CFTC charges. Goldman Sachs & Co. agreed to pay a fine of $15 million US to the Securities and Exchange Commission to resolve charges that it failed to comply with certain of its obligations under so-called Reg Show, the SEC's regulation governing the short sales of equity securities. Under Reg Show, a broker-dealer accepting a short sale of an equity security from a customer or engaging in a short sale in its own proprietary account must first borrow the security, enter into a bona fide arrangement to borrow the security, or have reasonable grounds to believe the security can be borrowed before the delivery date. These steps are referred to as the broker-dealer's locate requirement. According to the SEC, between November 2008 and mid-2013, GSCO, or Goldman Sachs & Co., used an automated system to handle the vast majority of its customers' short sale locate requests. This system would either grant in whole or part, deny, or send the request to a group of individuals known as the demand team for further consideration. The automated system was populated each morning with available inventory based on feeds from certain lending banks and brokerages that was haircut to be conservative, and were reduced each time shares were used to grant a locate request. Over time, an increasing number of locate requests were referred by the automated system to the demand team, and the demand team routinely processed requests by using an application that solely considered each day's beginning day share inventory rather than the inventory reduced by prior intraday locates. As a result, the SEC charged Goldman Sachs with executing certain short sales without reasonable grounds to believe that the securities to be sold short could be borrowed to meet its delivery obligations. The SEC also alleged that when its Office of Compliance Inspections and Examinations reviewed Goldman Sachs' lending practices in 2013, the firm, quote, created the incorrect impression that the demand team conducted an individualized review for all locate requests, end of quote, when it did not. Last week, 5 industry organizations asked the federal court for permission to weigh in on what are the appropriate legal standards the Commodity Futures Trading Commission must prove in a pending lawsuit against Donald Wilson and DRW Investments alleging attempted manipulation. The CFTC initially filed its lawsuit in 2013, claiming the respondents manipulated and attempted to manipulate the settlement prices of the IDEX USD 3-month interest rate swap futures contract on numerous occasions in 2011. In November 2015, the CFTC moved for partial summary judgment on its attempted manipulation allegation based on, among other matters, purported, quote, undisputed material facts, end of quote, that the respondents, through their conduct, evidence, quote, an intent to affect price, end of quote. The 5 industry organizations, CME Group, Commodity Markets Council, Futures Industry Association, Intercontinental Exchange, and Managed Futures Association, requested the court's permission to file legal papers as a friend of the court, claiming the CFTC misconstrued the correct legal standard of attempted manipulation. According to the 5 organizations, the CFTC should be required to prove, consistent with prior case law, that respondents intended to create an artificial price, one, quote, that does not reflect the legitimate forces of supply and demand, end of quote, not solely to affect price. The 5 organizations said that, quote, continued application of this traditional standard will facilitate the promotion of price discovery and the other congressionally endorsed public interests the futures market serve, end of quote. And finally, the Basel Committee on Banking Supervision issued a revised capital framework to purportedly better account for market risk by banks. In doing so, the committee proposed changes to the requirements for internal models that might be utilized by banks to calculate risk, as well as changes to a standardized model that is used by default by banks not using internal models. Among other things, internal models will be required to utilize a new measure of risk, expected shortfall, instead of the traditional value at risk and stress value at risk models. Expected shortfall, according to the Banking Committee, quote, measures the riskiness of a position by considering both the size and likelihood of losses above a certain confidence level, end of quote, better capturing tail risk. These are the extraordinary unlikely risks. In addition, the new framework provides for more, quote-unquote, granular internal model review processes, requires approval, quote, down to the level of the regulatory trading desk, end of quote, and limits the capital-reducing impact of hedging and diversification. The Banking Committee estimates that overall its new framework will cause the amount of banks' risk-weighted assets attributed to market risk to increase to 10% from 6%. I, for one, will miss value at risk and never get used to the acronym for expected shortfall, ES. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. Until next week, I'm Gary DeWaal. Have a great week, and as always, ciao.